law of self-defense content you are about to enjoy is presented for general educational purposes only. It does not constitute legal advice. If you are in need of legal advice, consult competent legal counsel in the relevant jurisdiction. Welcome, everybody. Welcome. Come on in. Make yourselves comfortable. Welcome to the Law of Self-Defense News and Q&A show for May 6th, 2021. Can't believe it. It's May 6th already. For those of you who may not know, I am attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you very much. That's always greatly appreciated. So welcome to our weekly news and Q&A show. We do the show every Thursday at 4 p.m. Eastern Time. We do it live at that time. Then we do make a recording of the show available afterwards. To watch it live, you can view it on our Law of Self-Defense Facebook page. Or if you're a Law of Self-Defense member, you can view it in your membership dashboard as well. And comments and questions submitted through that membership dashboard obviously get priority over Facebook because of the gracious support of our members. Thank you very much. This is the only weekly content we produce is open access. Most of our Law of Self-Defense blogging, videos, podcasting is available only for our Law of Self-Defense members. As you might imagine, I'll talk more about that in a moment. But this is our open access, no membership required weekly content that we put out for the public, for all of you, so you can get a sense of who we are at Law of Self-Defense and what we do. And what we do, of course, is use of force law. We specialize in self-defense, defense of others, defense of property. That's all we do. We don't have a generalized criminal defense practice. We don't do DWIs. We don't do shoplifting cases or anything that does not involve use of force law. In fact, we don't take clients directly at all. All our clients are other attorneys. We're, in effect, legal consultants to other attorneys who are lead counsel to their clients who have been charged in some use of force case. So that's the nature of our law practice. So come on in, folks. I had a few glitches with the membership dashboard stream of this, but chat should now be enabled there on the membership dashboard. And of course, chat is available on Facebook as well. So let me open up some stuff here. It's been an extremely hectic period here at Law of Self-Defense. So let me make sure I'm checking all the boxes I need to check. By the way, I do want to say up front, I'll cover a few use of force events in the news, of course. That's what we do here. But what we also do is take questions. Now, a bunch of questions are routinely submitted ahead of time. We have a list of those ready for today's show. But if you would like to submit questions during the show itself, you can email them to show@lawofselfdefense.com. That wasn't the slide I meant to put up. I actually won't check email, so don't email them for today's show there. Just put them in the comments on Facebook for the live show or in the membership dashboard for today's live show. For next week's show or a future show, if you would like to send us questions, you can email those to us at show@lawofselfdefense.com. We'll be happy to consider them for a future show. If you're a platinum level member of Law of Self-Defense, you have your own Q&A submission form. You should use that to submit your questions. Those get the highest priority. Plus, we'll answer those in private if you prefer. Just indicate as much in your Q&A form. All those Q&A questions come directly to me, folks. So you have confidence that they're not being viewed by others. If you want a private response, we're happy to provide that to our platinum members. So let me pull that back down and get the appropriate slide back up. So we have a number of, let's try that again. We have a number of items in the news to cover that have been of interest over the last week or so. I do want to mention, by the way, for those of you who are either watching live or the video recording after the fact, if you are a podcast kind of person, I know many of us are, certainly I am. I listen to my share of podcasts, especially if I'm taking a trip on the motorcycle. That's a good chance for me to catch up on my podcast listening. We do have a podcast for this weekly show, the Law of Self-Defense News and Q&A free podcast. It's on all the major podcast platforms you could imagine. You can get links to all of those depending on your preference at lawofselfdefense.com/free podcast. But that would give you this weekly show in podcast form for those of you who may want to take advantage of that opportunity. This is separate. The free podcast for this show is separate from our members only podcast, which covers all our other content over the course of the week. So if you're a member, don't think they're duplicative. They're not. This free podcast covers only this open access weekly news and Q&A show. All right, so I think I've touched on... Oh, no, of course, there is one more thing. I can't believe I almost forgot. My good friends at CCW Safe. CCW Safe is a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, they promise to pay their members legal expenses if the member is involved in a use of force event. I think this is a great organization. These are the providers of this kind of service that we most frequently partner with, and we do partner with CCW Safe on a regular basis. There may be more of that to come, by the way, folks. I was just chatting with CCW Safe HQ today about perhaps doing some specific content just for their members, some specific law self-defense content just for their members. Those are still exploratory discussions, but I hope they come to fruition. That would be a lot of fun. I certainly love working with Don West, who's their CCW Safe National Trial Counsel. So as that develops and I'm able to, I'll share more with you about that. But if you'd like coverage for a use of force event, and coverage is important, folks, unless you're independently wealthy, if you're involved in an aggravated assault with a weapons case, which is what you would typically be charged with if you displayed your weapon, didn't fire a shot, didn't hurt anybody, and end up facing criminal charges, it's typically aggravated assault with a firearm. You're looking at paying your lead attorney $30,000 to $50,000 in a retainer for pre-trial work, folks. That doesn't even cover the trial. A murder case, manslaughter case where you actually killed someone in self-defense, and now you're defending that conduct at trial, you're looking at spending a couple of $100,000 easily before the trial, folks, and then just multiply that for the trial itself. So these cases get very expensive very quickly. If you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself, your family, your property, then it might be prudent to make sure you have the financial backing you need to fight that legal battle the way you want it fought. And the way you want it fought is as if the rest of your life depends on it, folks, because it really does. So whether or not I'm personally a member of CCW Safe, they're the best fit for me. Whether they're the best fit for you is something only you can decide. Whether you need such coverage at all is something only you can decide. But I do encourage you to take a look at what they have to offer at lawofselfdefense.com/CCW Safe. And if you do decide to become a member of CCW Safe, you can save 10% off your membership with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Okay, so that should be all the boxes I needed to check before we can dive into the substantive news of today's show. So let me open up my notes here, see what we have in the list. And again, folks, if you'd like questions answered, if you'd like to submit questions to be answered during today's show, you can do that in the Facebook comments or the comments, the chat of the Law Self-Defense membership dashboard. I won't look at them in real time, but before the end of the show, we try to cap the show at no more than an hour. If we have time permitting, I will flip through the comments and look for those questions. So one of the news items that has come up, of course, is that Derek Chauvin has filed a motion for a new trial. We did a blog post on this for our members earlier this week, just a couple of days ago. So what do you need to know about this? Well, there's a couple of grounds for which a whole bunch of grounds for which the request for a new trial was filed. Now, frankly, that it was filed is not surprising at all. It's almost just SOP to file these kinds of requests. It's normal practice. You always ask for in essence, a directed verdict at the halfway point in the trial, arguing that the state failed to prove its case beyond a reasonable doubt without the defense even having to argue against it. You're almost always denied when you do that, but you always make the effort because sometimes it works. Who knows? And you always file for a new trial when you get a guilty verdict, if you're the defense counsel, for your client, almost always rejected. But this case is unusual because we have so many substantive grounds that would justify a new trial. The failure of the judge to change venue, the failure of the judge to sequester the jury throughout the trial, failure of the judge to tell the jury not to look at any media, as opposed to what he did tell them, which was, well, don't look at news about this case. It's impossible to filter the news in that way in this modern era of social media. So they're invariably exposed to these news stories about the case. There's grounds based on the judge allowing cumulative evidence in the case, meaning that he allowed many, many witnesses whose testimony was basically all the same. That's not generally permitted. It becomes prejudicial evidence because of the cumulative nature. It's as if there was some kind of alleged criminal offense that took place in a stadium with 50,000 people in it. The prosecution can't bring in 50,000 witnesses to all testify about the same event, basically provide the same testimony over and over and over again. And that's basically what happened here when the state rolled through bystander testimony after bystander testimony over bystander. And they were all standing beside each other. They all saw effectively the same thing. And not only was it cumulative, but then the state basically had them testify about their feelings. And witnesses are not supposed to testify about their feelings, folks. They're supposed to be fact witnesses testifying about what they actually saw. And then, of course, now we have this particular juror here, circled in the red in the image. Excuse me. Who appears to have been a sabotage juror, appears to have misled the court during voir dire about his ability to be impartial. Clearly, he had strongly held beliefs about the case going in, and he concealed those from the parties and from the court. So, more grounds for. Remember, folks, every one of us has a U.S. constitutional right to an impartial jury. Impartial jury. So, to the extent that the jury was in any way, even one juror, not genuinely impartial, that's not a fair trial, folks, by definition, under the U.S. Constitution. And yes, the Sixth Amendment does apply to state trial cases as well, not just federal trial cases. So to the extent that this juror effectively lied about being impartial, such that Chauvin did not get a genuine impartial jury, he's entitled to a new trial. Now, whether the outcome would be any different in a new trial is an entirely separate question. Frankly, I'm of the belief that if a fair trial cannot be provided to him, the solution is not to provide him with an unfair trial. That's not justice. The solution, consistent with justice, would be to dismiss the charges with prejudice. If society cannot provide him with a fair trial, there ought be no trial at all. That's my position. Whether any trial judges or appellate court judges would be willing to take the political heat such a decision would involve is, of course, a separate question. So I am working on a more extensive write-up of all of the grounds for a new trial that were set forth by Eric Nelson. Some of them are quite detailed. They have things to do like with purported errors in the jury instructions on second-degree murder, for example. So obviously we want to make sure we get those legal details right. So it's taking a little longer than usual to pump out that more detailed blog post, video, podcast content on that particular issue, the legal merits of this motion for a new trial. When we do have it finalized, of course, that will be members-only content. So if you're a law self-defense member, that would be one of the benefits of being a member of law self-defense. If you're not a law self-defense member, I kind of have to ask, why not? It's almost free, especially to try. In fact, you can get a 2-week trial membership at Law Self-Defense for just 99 cents. And if you decide in that 2 weeks you don't like it and cancel, we'll give you back not just 100% of your money, but 200% of your money. So it's a negative risk proposition. And if you stay a member after the 2 weeks, and folks, everybody does. We just don't have people leave. They like what they get from their Law Self-Defense membership. If you stay a member, it's only about 25 cents a day to be a law self-defense member. So less than $10 a month certainly does not break the bank. But the best way to make an assessment of whether or not it's a good fit for you would be to try it out. So we urge you to take advantage of this 2-week, 99-cent, 200% money-back guarantee trial membership at Law Self-Defense. And you get all the same access as any other member, folks. It's unlimited. There's hundreds and hundreds and hundreds of blog posts, videos, podcast content available for you, even as just being the trial member. Same benefits as everybody else. And you can learn more about that at lawofselfdefense.com/trial. Invest 99 cents, folks. That's my recommendation. Give it a shot. See if you like it. So the next news item we have up. What else? Is checks my notes. Oh, Officer Rolfe. So Officer Rolfe was, Garrett Rolfe was the Atlanta police officer who shot and killed Rayshard Brooks. You may remember Mr. Brooks. He apparently passed out drunk in a fast food, a Wendy's drive-through. So he's passed out in his car. They call the cops. The cops show up. Rolfe is one of the two officers who arrive. They get Rayshad out of his car. They go to arrest him for DWI, and he decides to fight arrest. He fights the two police officers to the point where they're unable to subdue him, and he manages to strip one of them of the officer's taser. Not Officer Rolfe, but the other officer. Takes his taser, begins to run. He's pursued by Officer Rolfe, and as he's running, Rayshard Brooks turns, looks over his shoulder, points the taser at Officer Rolfe. Officer Rolfe shoots and kills Rayshard Brooks. Looks like a lawful use of defensive force by that officer to me every day of the week and twice on Sunday. But this immediately became a highly politicized case. Of course, Officer Rolfe is white and Rayshard Brooks was black. It's the nature of these cases these days. And the prosecutor in that jurisdiction at the time was having great difficulties in his re-election bid. He was just about to be running again for election to that prosecutor's position. So he immediately brought charges against Officer Rolfe, including charges as serious as murder. And Rolfe was immediately fired from the Atlanta Police Department. Well, guess what, folks? He just got his job back because it turns out that the department completely violated its own procedures for the termination of a police officer, did not even bother conducting an investigation of what happened. And so the Atlanta Civil Service Board has reinstated Rolfe as a police officer. Now, of course, he's still on administrative duty. He's not on the street pending these criminal charges, but he does have his job back. By the way, that prosecutor who made that decision to criminally charge him lost his election. There's now a new prosecutor. The new prosecutor, frankly, wants nothing to do with this case, has already tried to toss this hot potato of a case to the state attorney general in Georgia, and the state doesn't want anything to do with it and tossed it right back. So now the local prosecutor is in court trying to get out from having to handle this case. I think we'll have a decision from the court within the next few days on that issue, but my expectation is the court will say, hey, you're the prosecutor in the jurisdiction. Either stick with the charges and try this guy, or dismiss the charges and don't try him. But when you ran for the job, prosecutor, this is the job. So we'll have to see what will happen with that. Another item in the news is this a little bit of video from some Antifa, the lovely Antifa crowd, again acting like little heathen monsters towards a bunch of diners in a restaurant. They're simply a repugnant and potentially sometimes extremely dangerous group of people. So they accost these diners in an outdoor kind of patio area of a restaurant in Louisville. And one of the diners presents a pistol. So there's a little video clip of that. If you haven't seen it, I'm about to play it for you. There is no sound on the video. The sound is really just a bunch of Antifa shouting at each other and at others. And there may have been cursing and stuff in it. I didn't want to take time to bleep it out. So we're just going to see the video, and I will talk over the video content of this clip. The person you'll want to pay the most attention to here is the gentleman in the blue shirt. He's holding a little handgun, maybe some kind of Derringer type of handgun, very small. It would not be my personal recommendation as a handgun to carry for self-defense, folks, especially if what you're worried about is a mob scenario like this. Bring enough gun, have a real gun on you, unless, as always, there's the caveat, unless there's a really good reason not to. I personally find there's rarely a really good reason for me not to have just basically a full-size or reasonably compact pistol on my person in a real caliber, meaning 9mm or better. But in any case, he's got this little gun that he apparently had on him, perhaps in his pocket. Who knows? Doesn't look like he's set up for a holster. But there's another gentleman I also want you to pay attention to, and that is he's further back in the image. He's wearing a white shirt. He's bald. He's doing a hand gesture, a come-to-me hand gesture towards the Antifa people. And those Antifa people are largely on the left side of the screen. You'll also see a waitress who, well, I believe she's a waitress jumping around trying to get Antifa to go away. so they don't destroy this business and her job and her tips on this particular day. So thoughtful of Antifa to engage in such conduct. But here we go with that video clip. So there's a gentleman in the blue shirt on the right. He's a little obscured right now. There he is. He's got a gun in his right hand. He's holding it horizontally, parallel to the ground, pointed in the general direction of Antifa, not aimed, not sighted, aiming. The gentleman in the white, the bald gentleman, is doing the come to me hand gesture. Folks, just don't do stuff like that. It potentially makes you look like a mutual aggressor at best, like you're looking for the fight. You know what? I just noticed this other stuff is here. So let me clear that out, and we'll try that. The video is about to expire. I'll just play it again so we can try to see it without the obstruction. Here we go. So you don't want to appear like a mutual combatant, like you're offering an invitation to fight and another person's accepting the invitation, and now you're in a fight. Let's settle this like men. Let's be tough guys kind of approach. Because if you're a mutual combatant, folks, neither you nor the other guy has a legitimate justification for your use of force. You're both mutual aggressors in that confrontation. There's no reason to engage in such behavior. First of all, you don't want to be in a fight if you can avoid it. People die in fights. It's not a good thing to have happen. I'll roll the video one more time so we can see it while I'm talking. This is foolish, stupid behavior. It can really only have a negative outcome. What's the positive outcome? That you punched Antifa in the face? And now maybe you're charged. Now maybe you're getting sued. Who knows? By the way, you'll also note on the right here, there is a door that's unlocked that people are coming out of, meaning it's a door that people could go into. If I were one of the patrons here in the patio, the first thing I would do if I couldn't escape through Antifa would be to take the door behind me. A great way to win a fight for people like us, folks, is to not get into a fight in the first place. So don't engage unnecessarily. Don't allow yourself to be engaged unnecessarily. If you can safely get away from the prospective confrontation, then that's what you want to be doing. Now, if there were no door, if you're cornered, perhaps that's a different scenario. So let's imagine that were the scenario, that this gentleman in the blue shirt, angry crowd. I've read, although I don't see it here in this video, I've read that some were armed. Really, they're all armed anyway, right? When you have that disparity of numbers, they have the ability to present a deadly force threat. They have the opportunity to do it. They're right there, depending on the demeanor, the character, but certainly they look aggressive enough. Arguably, there's jeopardy there. So it's not the kind of situation where you could realistically defend yourself against an attack, even a barehanded attack against that many people without the use of a defensive weapon, such as a handgun. Not sure how much this handgun would help. It looks to me like it has a shot or two to offer. That's about it. So here we have a defensive display of a handgun. Now, we've written a lot of blog posts recently for our members about states passing defensive display statutes. It seems to be rather popular at the moment. So is a defensive display lawful or not lawful under these circumstances? The answer is we don't really know, because whether or not it's lawful or unlawful is going to be a judgment call made by other people, by responding police, by prosecutors, by judges, by jury. All these defensive display statutes are, to my mind, effectively circular reasoning. They're saying, well, if the display is made for defensive purposes, then it's not a crime. But who says it was for defensive purposes? Who says the circumstances justify that defensive display? That's a subjective judgment call that's going to be made by other people. I'm not a fan of defensive display of a handgun for the purpose of defensive display of a handgun. Now, if you believe you're being threatened with deadly force and you display the handgun in preparation to fire a shot, and then circumstances change, so firing the shot's not necessary, the bad guy sees the gun and he runs away, well, you don't have to follow through with the shot if the shot's no longer called for. In fact, it wouldn't be lawful for you to do that, and in effect, you will have made a defensive display. But you made the defensive display incidentally to actually acting in self-defense against an imminent deadly force threat. Circumstances changed, so you didn't have to fire the shot. But I'm not a fan of defensive display for the purpose of defensive display. Is what this guy did here, is it really any different than what the McCloskeys did in St. Louis? I would suggest it's not even as defensible. they at least were on their front yard, right? They at least are articulating that they believe there was a threat to their castle, so to speak. Maybe there was, maybe there wasn't. That's a discussion for a different day. But you certainly are in a more favorable position from a narrative perspective if you're making that defensive display against a mob while you're on your front lawn than you are if you're in a restaurant where you could just walk out the door behind you and not be part of the confrontation anymore. So if this is less defensible than the McCloskeys, why would this guy think that, I mean, they're facing felony charges with multi-year sentences hanging on the adjudication of their case. There's no reason this guy would believe he couldn't potentially face the same criminal charges, the same prison time, the same felony conviction. It's all up to the prosecutor whether or not you're going to face that. Now, we could say, well, in Louisville, maybe they have a reasonable prosecutor who wouldn't bring those charges. In St. Louis, of course, they had Kim Gardner bring those charges, a Soros-funded, highly political activist prosecutor who obviously had political motivations for bringing these charges against the McCloskeys. So we can say, well, charging the McCloskeys, that wasn't fair. Okay, fair enough, but it happened. In fact, it's happening. The charges are still in progress. By the way, Kim Gardner, if you don't know, the prosecutor in St. Louis or St. Louis County, the political framework of that area always confuses me a little bit. But the prosecutor who brought those charges is responsible for that case. Well, she's no longer responsible for the case because she used her bringing charges against the McCloskeys as part of her reelection campaign in emails. This was prosecutorial misconduct sufficient for the motion to have her removed from the case be approved by the trial court. And when that decision was appealed by Kim Gardner to the Court of Appeals, they affirmed it. You're off this case because of your misconduct. And then when she appealed it to the state Supreme Court, the state Supreme Court said, nope, you're off the case because of your misconduct. So she's not even on this case anymore. There's a new prosecutor who's been assigned to this case. Whether or not they proceed with the charges, they haven't done away with the charges. They haven't dismissed them. So technically the case is still in progress. I know there's a hearing on this, I think within the next week or so. So perhaps the charges will be dismissed by the new prosecutor. We'll have to wait and see. By the way, that's not the end of Kim Gardner's Soros-funded prosecutor's problems. She was involved in another case when she first won her first election to prosecutor. She immediately brought criminal charges against the Republican governor of the state. She did, in fact, manage to compel him to resign that position. All those criminal charges were ultimately dismissed. And in pursuit of these criminal charges, apparently politically motivated criminal charges against a political opponent of the opposite party, she hired some kind of wacko private investigator who collected purported evidence of misconduct by the governor. She had this expert testify in court under her questioning, and the expert was lying about the evidence he claimed to have, and she knew he was lying. And this has all been exposed now because a complaint was filed against Kim Gardner with the board. I forget the technical name they use in Missouri, but the board that oversees lawyer conduct in the state, including the conduct of prosecutors, that reports directly to the state Supreme Court, which is the sanctioning body for legal practice in the state. He submitted, it's like a 60-page memorandum to the state Supreme Court saying Kim Gardner engaged in terrible misconduct. In this case, she knowingly let a witness lie in court, to the court. And Kim Gardner is now looking at the prospect of potentially being disbarred from the practice of law, period, which would make her an interesting prosecutor for that jurisdiction. We'll see what happens there. I do have the memorandum, the 60-page or so memorandum filed alleging unbelievable misconduct by Kim Gardner, and I have her response to that memorandum filed with the court, which basically is saying, hey, look, this is a politically motivated witch hunt against me, which is ironic because her misconduct occurred in the course of her, Gardner, engaging in a politically motivated witch hunt of the governor sitting at the time. But she's saying, hey, this complaint is the 60-page memorandum is just politically motivated. And by the way, I concede that, yes, errors were made. Well, the errors were intentional. They weren't just made. They didn't just happen. These were not accidents. So we'll have to see what happens with that. I certainly would not shed a tear, and I imagine the McCloskeys would break open a bottle of champagne if it turns out that this woman persecuting them in this way ends up herself being disbarred from the practice of law. All right, let's see what else we have. I talked about that. I think it's time to get to the question. So it is indeed. Let's see, how are we doing for time? Oh, good. Plenty of time. So don't forget, folks, you can submit questions in the Facebook comments or in the comments on the, if you're a law self-defense member, comments on the chat on your member dashboard. And again, if you're not yet a law self-defense member, I have to ask you why. It's only 99 cents to try it out for 2 weeks, folks. You get the same access as any full-paying member for that 2-week period. If you decide you don't like it within that 2-week period, let us know. We'll cancel your membership, give you 200% of your money back. If you decide to stay a member, and just about everybody does, folks, it's only about $0.25 a day to be a law self-defense member. Doesn't break the bank, less than $10 a month. But the only way to really know if it's a good fit for you is to try it out. So that's why we have this 99-cent trial membership, and you can learn more about that at lawselfdefense.com/trial. All right, let me pop up my title slide for whoops, that is not what I wanted. Try that again. And remind you all who I am, Attorney Andrew Branca. That is also not what I wanted there. So many slides. There we go. Okay, and now let's jump into some of the questions that were sent in. One comes from Rodney M. He sent in a question about using personal hand-loaded ammo for self-defense. So you load your own ammo. I load my own ammo, folks. I've got a Dillon 650 XL. Had it for decades now. Loaded certainly in excess of 100,000 rounds on that gun when I was a very active competitive shooter. So I know all about making your own ammo. I make my own ammo. It's wonderful. But should you use that ammo as your personal self-defense ammo in your sidearm that you carry for serious purposes to defend yourself, your family, and others? So that's the question. Now, I will tell you up front that if that's the only ammo you have, then that would be the ammo you carry. So if the choice is between carrying your own loaded ammo or having nothing, well, then you carry your own home loaded ammo. Right? So I want to be very clear about that. I'm not suggesting anyone should go unarmed simply because the only ammo they have is the stuff they loaded themselves. If that's all you have, then that's what you use. If, however, you have the option to use factory-loaded ammo, high quality, I'm presuming quality, factory-loaded self-defense ammo, then I would urge you to use the factory ammo for a number of reasons. One is just practical. First of all, of course, the factory stuff is expensive, especially these days, right? Ridiculously expensive. But you really don't shoot it, folks. Not very often. Periodically, once a year, a couple times a year. I mean, it depends on you. You might burn through what you have in the gun and load it up with stuff from a fresh box. But it's not ammo that you're routinely burning through. I wouldn't expect. If so, you're a lot wealthier than I am. But you don't use it up, really, for all practical purposes. So the fact that it's expensive up front when you buy it, $1 a round, $2 a round, whatever it may be these days, I recognize that can be a hardship. But unless it's a real hardship, unless it's a choice between that and food or that and rent or that and your car payment, then I would urge you to use the factory ammo. Cost should be set aside for that purpose. It's not that much. Now, the legal concern here is that many people I respect, Masada Ayub, for example, has argued that if you use hand-loaded ammo in court, in self-defense, it can be used against you in court. That the prosecutor can argue, ladies and gentlemen, this defendant not only killed the victim here with malice, not self-defense, but it was a malicious murder, unlawful killing. But he was particularly malicious because he loaded extra deadly ammo himself. The stuff at the store, the stuff that the cops use, the stuff that the bailiffs carry here in the courtroom was not good enough for this defendant. He really wanted to kill. Can a prosecutor make that argument in court? The answer is yes, absolutely. The prosecutor can make almost any argument they want in court. Now, how much traction would that get? How much of a difference would it make in the trial? It kind of depends on the nature of the facts in the case. So if you have an otherwise robust narrative of self-defense, it otherwise looks like a clean shoot, I don't think you using hand-loaded ammo is going to change that. It's not a fatal blow to an otherwise robust claim of self-defense. That said, if you're at trial, it's likely because you don't have an otherwise robust claim of self-defense. Your claim of self-defense may look borderline, ambiguous, uncertain, subject to disproof beyond a reasonable doubt. And if the prosecutor perceives it like that, well, it may be self-defense, but it may not be self-defense. Let's take a shot at it. It's sufficiently ambiguous that we have a chance to win here. Well, then the hand-loaded ammo argument, while not having a lot of traction, may be just enough to push it over the edge, to convince the jury that either it has disproven self-defense beyond a reasonable doubt, or it's some kind of aggravating factor in terms of the degree of the offense, or even if it doesn't influence the jury so much, maybe they would have convicted you anyway, regardless of the hand-loaded. Well, once you're convicted, then all kinds of factors can be considered by the judge in sentencing as aggravated factors that maybe wouldn't even have been relevant or admissible during the trial itself. And you don't know if the judge might be amenable to an argument by the prosecution that your hand-loaded ammo shows particular malice, should be an aggravated factor in sentencing. And that can make a big difference, folks. These aggravating factors can add years and years and years to a sentence. In the case of the George Floyd killing, for example, Derek Chauvin's been convicted now of all those charges that were brought against him. Under the normal sentencing guidelines, as someone without prior convictions, he'd probably be looking at 10 and a half years of prison time, sentence, I should say, and probably serve 2/3 of that, maybe something like that in the ballpark. So 6 years, and he could be out. But there's a lot of aggravating factors in his case that the state is arguing should apply in sentencing. Things like he was a cop in uniform, he was being observed by witnesses, he was part of a group, children were observing the acts, and those could easily double the effective sentence that he's looking at. So these aggravating factors can be a big deal. Now, if the chances of you using your hand-loaded ammo, the chances of it having a substantive negative effect on you legally is low, then why should we be concerned about it? Because low is not zero, folks. Low is a real risk. And why incur any risk when you can mitigate the entirety of that particular risk by going to your local gun store and buying a box of ammo? It just doesn't make any sense to me. And by the way, the factory ammo is probably better than your hand-loaded stuff. Those guys who do it with factories and testing, especially if you buy stuff that's really well tested. My personal preference for carry ammo for serious social purposes is I've got friends who either worked at or still work at the FBI. Whatever you may think about the FBI these days for political purposes, they test the heck out of ammo. So whatever the Bureau's assigning to its agents is typically what I carry for personal protection. I think that's still Gold Dot today, but I'd have to double check. But something to keep in mind. Hand reloads are probably not going to have the same kind of quality control. You might beg to differ. If you're a skilled reloader, that's up to you. But even if your loads are marginally better, they're not going to be decisively better in any physical combat over what Gold Dot, for example, might do for you. And they do raise that prospective legal issue, which even if small in risk is nevertheless more than zero in risk. So I would discourage it. So it's not a black or white question, folks. It's not absolutely this would gut your claim of self-defense if you use your own ammo, or is it that it would absolutely have no effect on your claim of self-defense, could never be used against you in court? Neither of those are true, folks. The answer is in the middle based on the factors we just described. Let's see, what else do we have? Well, I see. So a number of other questions that were submitted ahead of time. Actually, I rolled them into the news reports. They involved the gentleman at the diner, for example, and the McCloskeys case and the request for a new trial questions in the Derek Chauvin case. So let me take a look through the comments that have been made and see if any questions have been submitted during the live show. I'll go through our membership dashboard first. Hey, Brian, Scott, all the regulars are here. Jack, Jim, D, Leroy. Leroy asks, any Ashli Babbitt thoughts on the lawsuit, I guess, from her parents? I suppose her parents have filed the lawsuit. The answer is yes. I have definite thoughts on Ashli Babbitt, and I wrote an extensive blog post on them for our members. So, Leroy, you're commenting on the member dashboard. That tells me you're a member. I would just go to our blog post, just flip through the last. It was probably before the Chauvin trial started, probably right after the event happened. So just check the date of the event. It escapes me at the moment. And within a week after the date of the date on which Ashli Babbitt was shot, you'll find a blog post, video, podcast content on my views of that shooting as of that particular date. I don't think a lot of new evidence has developed since then, so I think my view would still hold true. In terms of the lawsuit, people file lawsuits for, obviously the parents feel they have a grievance here. They have a cause of action over the death of their daughter. It's hard to imagine any parents who wouldn't feel that way. And if the case is not going to be prosecuted, and certainly I would not expect, regardless of the legal merits here, I would not expect the Joe Biden Department of Justice to prosecute this case. It does not fit their political narrative. If the prosecutors are not going to step in to seek justice as they see it for Ashli Babbitt, then it's understandable why her parents would want to do that on her behalf. It seems the only way that there'll be any definitive answers about what actually happened. And certainly we don't know what was going through the mind of that officer who fired the shot. It would be nice to know that. And if he's legally sued, perhaps they have a prospect of learning what actually was going through his mind at the time. Of course, that would also require him to receive immunity from prosecution, or he'd have Fifth Amendment rights to not say anything about what was going through his mind at the time. So that is it from the members dashboard. Let me go through the Facebook comments here. Let's see. So along the lines of using your own ammo, Ken here asks, several people, Kim asks, Kim Green, what about a custom trigger, smoother, better, safer? How would that appear in court? So this is all gun modifications, legal implications of gun modifications. And I really put gun modifications into two buckets. One is, I should say 3 buckets. One are just cosmetic modifications. So stippling of a grip, replacing those terrible plastic sights that Glocks come with actual metal sights, even putting a dot on the gun, coloring the gun, stuff like that. I mean, cosmetic changes. And really by cosmetic changes, I mean things that do not affect either how the gun fires or any safety mechanisms on the gun. So doesn't change how the gun fires, doesn't change safety mechanisms. Cosmetic changes, I just have no concerns about at all, except cosmetic changes that allow an inference about your state of mind, or an arguable inference about your state of mind. So I'm talking about things like a Punisher backplate on your pistol, your effed dust cover on your AR, engraving wait for flash on the crown of the muzzle. And the same applies to things like bumper stickers on your car that says, kill them all, let God sort them out, that kind of stuff. Terrorist hunting permits. All those things arguably can be the basis for making an inference about your state of mind that's inconsistent with lawful self-defense. I mean, look at the Punisher backplate. Who's the Punisher? He's a vigilante who acts outside the law. So what are you saying when you put a Punisher backplate? Are you imagining you're that guy? Is that your worldview? Because that's what a prosecutor would argue from that. So cosmetic things don't really matter, legally speaking, unless they go to state of mind. So don't do those. And that leaves us with the third bucket, which is modifications that do change how the gun fires and safety mechanisms. And I do not recommend doing any of those on a gun that you intend to use for serious social purposes, for defense of yourself, defense of your family, defense of others. And by affecting how the gun fires, I mean things like substantive changes to the trigger weight. Now, a trigger that's smoother, I don't see a problem with if the overall weight stays about the same. So I'll use Glocks as an example. This is not to pick on Glocks. It's just because I happen to know the numbers. So a typical Glock trigger weight from the factory might be maybe 5.5 pounds, right? We're not talking crazy New York triggers. So 5.5 pounds. And of course they sell aftermarket kits for Glocks, or I imagine there's polishing and stuff that can be done for a Glock trigger that would make it, smoother than it might come from the factory. And if someone were to modify a Glock trigger so it went from 5.5 pounds to 5 pounds or 4.5 pounds, I don't think that would be that big a deal. It's kind of within the range of error. Range of trigger rates, right? They're not all 5.5 pounds. They probably range between 5 and 6 or 4.5 and 6.5. So you're still within that kind of normal range. But if you drop a kit in there that somehow drops your trigger weight in your Glock to 2.5 pounds, that's a big difference, folks. And that makes it, it opens the door for a prosecutor to argue that perhaps your shooting of that victim was not intentional lawful self-defense, but perhaps it was an accidental discharge. Perhaps you put just 2.5 pounds of pressure on that trigger when you didn't mean to. And so if it wasn't an intentional firing of the gun, well, then it wasn't lawful self-defense, folks. Lawful self-defense has to be an intentional act. And of course, we do see people accidentally shoot others. I mean, we just saw it with Kim Potter, right? Now, she thought she had a taser in her hand, but she apparently did not intend to shoot Dewante Wright, I believe it was. He got shot anyway. So unintentional shootings happen. And if it's an unintentional shooting, it's not self-defense, folks. So you don't want to open that argument to the prosecutor to make to the jury. Also, by the way, having a very light trigger on the gun under stressful circumstances, in fact, makes it more likely that you'll have an accidental discharge. It just does. It doesn't make it less likely, right? It doesn't keep the risk the same. Now, some of you are maybe extremely experienced shooting your handgun with a light trigger on it. I know I certainly was when I competed 10,000 rounds a year in practice fire with a 1911. Very nice 1911, very good trigger, light trigger compared to something like a Glock. I felt very confident in my ability to not accidentally discharge that gun. But of course, I never had to fire it while someone was coming at me with a bat either. So my recommendation is don't modify the trigger. If you make it smoother and the weight stays about the same, I don't see a problem with that. There's no real metric for smoothness. There, in fact, is at least one device I've seen on the market. I think it's the Cool Fire guys use it. If you know Cool Fire, they sell these CO2 devices for dry firing your gun. Great devices, by the way. Highly recommend you look at those. But they actually sell a device for manufacturers that measures not just trigger weight, but also kind of the smoothness, it graphs it out of the trigger over its travel. But most forensics, firearms, investigators at police departments would not have a device like that. They would have a trigger weight pull, of course. So they will notice big changes in trigger weight. Smoothness, I think, is not nearly as big a deal. In terms of safety mechanisms, please do not disengage, alter, modify any safety mechanisms on your gun. If you have a 1911 with a grip safety, don't pin or tape the grip safety. Don't deactivate any safeties. If you have a magazine disengage device, magazine disconnect, so that the gun can't fire if the magazine's out of the gun. I know many people don't like that kind of feature. I personally don't like it. But if your gun came with it, don't disable it, folks. Those safeties exist because the manufacturer believed they're necessary to the safe operation of the gun. You'll never convince a jury that you know more than the factory that made the gun, than the engineers that designed the gun. If you don't like a grip safety, if you don't like a magazine disconnect, if you don't like a thumb safety or whatever, well, don't carry a gun with those features. We're blessed to live in a world where we have an unbelievable assortment, variety of guns that are perfectly satisfactory for personal protection of others, that you can carry on your person. Just find one that has the safety features that you're comfortable with and carry that one. Don't buy one with safety features you don't like and then disengage them, because that will absolutely be found upon examination. And you're just opening the door to a bunch of headaches. So And by the way, I would suggest much the same for the triggers. I mean, I would not recommend you buy a gun with a heavy trigger and then make some modification to the trigger to lighten it. Go find a gun with a good trigger out of the box. They make them, folks. They're not that hard to find. And by the way, when we're talking about self-defense shootings, the typical ranges we're talking about, a standard factory Glock trigger is just fine, folks. If you can't get self-defense hits with that, I really don't. I don't think the problem's the trigger. All right, let me put it that way. Okay, let's see. Lorraine asks, if you carry a pocket knife and pepper spray on your person, but you use your gun in self-defense, are you exposed to a challenge then one might have chosen? Well, it's worded a little oddly, but the idea is you have a gun, you have pepper spray, you're attacked, you go to the gun to defend yourself. Could a prosecutor argue that, hey, you had the pepper spray, you should have used that instead? Well, again, prosecutors can argue almost anything they want. So I can't say they can't make that argument. They'll be allowed to make it if they want to. The real question is, what kind of traction will it have? Now, you should only be going to the gun if you're genuinely facing a deadly, imminent attack. And if you are, the gun's the appropriate response. He can't argue that you're limited to pepper spray if you're facing a deadly force attack. That's not what the law is. And in any case, what's the alternative? Is the alternative to either not have a gun, only the pepper spray, in which case, how do you defend yourself against a deadly force knife attack? Or is the solution to only have the pepper spray and not have the gun, in which case your only defensive tool is a deadly force tool suitable only against deadly force attacks, but you don't have anything to defend yourself against the 5 times more likely scenario, according to the FBI and Department of Justice crime statistics, 5 times more likely that you'll be facing a non-deadly force attack against which the gun is not an appropriate defensive tool. So is it possible a prosecutor could argue, hey, you had pepper spray and a gun, you should have used the pepper spray? Yeah, he can make that argument, but so what? You need to, if you went to the gun, you need to be prepared that the use of the gun was justified anyway. And the consequences of not being prepared for the real world by having both pepper spray and the gun vastly offsets the theoretical risk that a prosecutor may raise an argument that in any case, you're going to have to justify the deadly use of force regardless. Let's see. Brian asks, what about using a custom AR in self-defense, particularly in your home? Well, the rules are different in your home. If not technically as a matter of black letter law, then in terms of narrative. By definition, if you're in your home, that aggressor came to you and breached your home. In most states, there will be a legal presumption that you had a reasonable fear of imminent deadly force attack. That's a presumption very difficult for the prosecutor to overcome. This is when I say that these kinds of issues, using your hand loads, modifying the gun, they don't destroy your claim of self-defense inherently. It's not like violating one of those 5 core elements of a claim of self-defense. They're not that decisive. But a marginal case of self-defense might be pushed over the edge by those factors, so why incur that risk unnecessarily? What's the offsetting benefit? I just don't see one in a self-defense context. But if you're defending yourself in your home from a forcible, unlawful intruder who's entered your home, that's not a marginal case of self-defense. I don't care if you use a spear to defend yourself. I mean, which would normally look crazy if you were out in the street, right? In your home, all the presumptions are so profoundly in your favor that unless it's a really weird scenario, like the person you're claiming was an intruder is your wife's new boyfriend or something, something to suggest some motivation other than defense of your home, defense of yourself. I don't see the choice of weapon or ammo or customization having anywhere near sufficient weight to be legally troublesome inside your home. But that could change if you go outside your home like the McCloskeys did. So please don't do that. Okay, what else? Let's see. We got 4 minutes left. Tony asked, do I know of any other providers like CCW Safe that provide real-time jury consultant and social media consultant? I don't. In fact, I'm not sure I knew that CCW Safe provided that. I should mention, folks, I don't work for CCW Safe, so I can't claim to be an expert on everything they do. I've compared their most important features, important to me as a lawyer, from a legal perspective, their most important features. I have compared and contrasted those against their competitors. And on the features that are most important to me, they're clearly ahead of most of their competitors. This other stuff, like having a real-time jury consultant, well, I'm not sure what real-time means. I mean, can't use them until there's a jury anyway, or at least jury selection. But yeah, those are all valuable things to have. Now, frankly, I would expect a lot of that to be arranged by the attorney, by the defense attorney, to hire whoever he thinks or normally uses as a jury consultant. And I would expect CCW Safe or any of their competitors to pick up that tab. That's part of the legal defense. Otherwise, what's the point of having the coverage in the first place? But yes, I think it's, to the extent they have that stuff. And some of these plans will cover like your lost wages while you're in court and things. I don't really care about those features. They're not decisive from my perspective about the issues that really matter, like whether you're actually going to get convicted, sentenced to 20 years to life in prison. But they're nice to have, and they may make a difference for any one of you in terms of, choosing which program is the best fit for your personal circumstances. Let's see. Ken's having trouble getting to his members only area at Law Self-Defense. Ken, if you're asked to, there's a little window that pops up, something about a two-step verification. There's a skip option on that window. Just click skip. Forget the two-step verification. For some reason, on some browsers and systems, it causes trouble. You don't need it. Trust me. Just skip it. Let's see what else. Let's see. Let's see. Can I give my thoughts on what's happening in Myanmar? Is that the old Burma? I don't know what's happening there, so I'm afraid I cannot. If you'd like to, if you want to email us at show@lawselfdefense.com with some facts or links, I'll be happy to address it. Of course, I don't know anything about their law on use of force, but I could certainly apply American principles of use of force law and explain it in that context. All right, folks, we're bumping right up against the top of the hour. The last thing I want to mention is I did touch upon the fact earlier that we do legal consultation to other attorneys. That's the nature of our law practice. We don't take clients directly. Our clients are all other attorneys who are representing their clients, but we only do legal consultations to people who are Platinum Protection Program members here at Law of Self-Defense. This is our highest level of membership we have here at Law of Self-Defense, our platinum level of membership, and it guarantees my availability to consult on your case if you're involved in a use of force event. And perhaps as importantly, not only do you have my availability guaranteed, but my availability is free. In other words, it's part of being a Platinum Protection Program member. Our flat retainer, base retainer for consulting on cases is now $10,000, folks. And you don't have to pay a penny of that if you're a Platinum Protection Program member and you need us to consult on your case. And by the way, you're not limited to any particular dollar amount of consultation from us. If you go to trial, you'll get our legal consultation. If it's a hung jury and they're going to retry you, you get our consultation again. If you're convicted and you're appealing your conviction for purposes of the appeal, you get our consultation again. We are there with you through the entire process at zero additional cost to you. Now, this is not a replacement for something like CCW Safe. This does not cover your legal expenses. Generally, it covers the expense of me to consult on your case. So I want to make that clear. If you'd like to learn more about this possibility, guaranteed to have me available for you and at no cost, because you're a Platinum Protection Program member, you can learn more about that at lawselfdefense.com/platinum. All right, folks, I think that is all I have for all of you today. Join us again every week. Again, try out that Law Self-Defense trial membership at lawselfdefense.com/trial. 99 cents, folks, 200% money back guarantee, negative risk proposition. You can't not win. So try it out, lawselfdefense.com/trial. Until we meet next time, remember, If you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you owe it to yourself and your family to also make sure you know the law so that you're hard to convict. All right, folks, I'm Attorney Andrew Branca for Law Self-Defense. Stay safe.